Welcome to Navigating Receiverships, a podcast from the Commercial Receivers Association, focused on building a better understanding of what brings companies into receivership, what happens in receivership, what makes them unique, some alternatives to receiverships, and ultimately, what happens to the business as the receivership is closed out. I'm one of your hosts, Eric Morcheski, CRA board member and CEO of Nimble Strategies. Welcome. We're here today with Judge Elizabeth Gunn. This is kind of an exciting episode for us as you're our first judge to be on the podcast. Judge Gunn, thank you so much for joining us. Can you tell our listeners a little bit about yourself?
Well, thanks for having me, Eric. As you said, Elizabeth Gunn. I'm the bankruptcy judge in the District of Columbia. I've been on the bench since 2020. Before taking the bench, when I was in private practice, we had a couple of receiverships. We represented the receiver in at least two Virginia SEC receiverships. And then for 5 years in between being in private practice and taking the bench, I worked for the state and did nothing with receiverships. But it's definitely something I had familiarity with, and I'm really glad to join you on the podcast today.
Thank you. And we're going to talk a little bit about some of these properties that are kind of funneling their way to you through the DC Attorney General's office and then the district courts. Tell us a little bit about, what's bringing these cases into you first. Let's start there.
Well, obviously, I'm a bankruptcy judge, so I don't get any of the juicy SEC receiverships unless and until someone decides to file a petition, and then those issues. And I haven't had, I mean, fortunately or unfortunately, I there hasn't been one in DC yet when I've been on the bench. But what I do have is a very interesting receivership law under the District of Columbia state law, or whatever you want to call it. We call it state law. It's the District of Columbia law, in that they have an ability to put in kind of almost a limited receiver over real property in such that they don't displace management. So management still owns the company. Management still has all of the managing decisions, but the DC Superior Court, upon motion of the Attorney General, and we can get into why they do that in a minute, will appoint a receiver to essentially, it's almost like a CRO. Their job is to take the money in and to spend the money. And this occurs in a way that they will usually require payments from the owners then to improve properties, but the manager, the receiver is kind of a property manager responsible to the court, but also to do repairs. So these cases arise really out of slumlord cases, property issue cases, and I would love to say it's a result of last resort or a remedy of last resort. And I don't know if we just have a prolific number of people who are not maintaining their properties in the District of Columbia, or we have a particularly aggressive enforcement mechanism, because we have a lot of these properties. I've seen in the 5.5 years I've been on the bench, I've had more than a dozen different properties coming through with receivers involved, where the managers, the owners, because they maintain management, have filed bankruptcy to get basically to try and stop what the receiver's doing or to stop some of the enforcement mechanism in Superior Court. But they don't have control of the cash. They don't have control of the rent. There's a debate between who has jurisdiction, which I think we're going to get into. But I'd love to call it the parade of horribles, because by the time the properties have a receiver and by the time the management decides maybe we need to do something about this and file a bankruptcy, I get pages and pages. And when I mean pages, I mean tens and hundreds of pages from the Attorney General's office documenting what we call the parade of horribles. There's roaches, there's rats, there's no electricity, there's mold, there's leaks, there's no front door to the property, there's squatters, there's broken windows, there's all of these things that for years and years and years the owners have been cited to remedy. And, DC government takes a lot of flack for not being super effective at things. One thing they are really effective at is citations for building code violations, because I've had cases with thousands of outstanding, what we call DOB violations, where every single thing kind of gets its own number. So if the stove's not working, that's one violation. But if they're in the same apartment and there's a water leak in the ceiling, or there's rat feces on the floor, that each of those is a different violation. So we see these cases with all of this stuff, and yet I'm faced with an owner who says, I'm still trying to maintain my property. I can't do it while Superior Court is telling me I can't take my rents, I can't do anything, I can't take out a loan, I have to answer to the receiver. A lot of times they don't get along with the receiver. And so it puts me in an interesting jurisdictional position as to what can I do and what can I do, because it's not a full-fledged receiver. It's not an SEC receiver like you're used to, who has either the authority, the sole authority to file a bankruptcy or not. It's this weird middle ground where I have this receiver, and how do I get along with Superior Court, and who has jurisdiction over what? And we've had some really interesting cases that have come out of that situation.
Yeah, so you called it what I would call it in Missouri. We call it a limited receivership, and some states call it books and records, where basically you take control of the financials. Can you walk our listeners through what that process is looking like from the AG making that decision essentially to go pursue one to how they're ending up in your court?
So it usually starts with a lawsuit in Superior Court, Attorney General versus usually the property owner LLC and the owners of said LLC, because there's some pass-through statutory liability that they can get to the owners on these violations without piercing the veil. It's almost like responsible party taxes. They can get everybody into the lawsuit. And so it starts with a lawsuit essentially for the violations of the building and health codes. And what they really want is just like when you sue somebody for non-payment of child support or something, they just want them to fix the problem. I mean,
Mhm.
ideally, they say you have X number of violations, you haven't cured them. We've told you you haven't cured them. Now we're having to file this lawsuit to allege you haven't cured them. And sometimes they'll ask for the appointment of the receiver at that point. Sometimes they bring them in and say you need to cure the violations or we're gonna get a money judgment against you. It's when they continue to have more violations build up that either they amend the complaint to add a separate receivership count, or it's a contempt violation sanction. Now, what we see a lot of times is the building owners will get in, and what DC is asking for is a remediation plan. It's almost like a plan of reorganization or a plan of scheme of distribution or something. They want the property owner to say, okay, you tell me I have these 20 violations. Here's how I'm going to cure it over time. And if they can come to a settlement, they'd rather get that approved by the court. If that's approved and then they violate the plan, you can guess that the next motion is to appoint a receiver to enforce the plan because they haven't, agreed with the court order. Sometimes in the really egregious cases, they just pass that and they say, we don't trust these guys from here to Sunday. Or if they're a repeat offender, they'll just skip right to asking for a receiver. So it really all happens in Superior Court in the District of Columbia. And it probably happens over about a 1 to 3 year period, depending on how long. I mean, so it goes on quite a while. And one of the things, legal aid is frequently involved. One of the things I get legal aid, these people have been living in deplorable conditions for 4 years while they fought about this in Superior Court. I'm like, great, but I've had this 4 minutes, so we have to figure out what's going on. Usually what happens in that order, those remediation plans or an ordered remediation plan from a receiver, is if there's a remediation plan, they say how much has to be put into the property to fix the leaks, the rats, how much, if there's hard capital that has to be invested or whatever. If they don't have that and limited receiver is put in place, the first thing that receiver does is usually $60,000 inspection and analysis of the property. And I say that because they're not cheap. Like the receiver gets to charge an hourly rate. They hire experts in mold remediation and all those things. And they prepare what is usually something like 100-something page report, which takes about 6 months. And they say, here's everything we do to make the property perfect. And one of the questions I have, and this is just me speaking, but there are different levels of what is habitable and what properties should look like. And a lot of times it seems like the receivers are trying to take a Class D property and like, if I do everything I want, it could be Class A space. And you're like, maybe we should take this. And, I don't know. I don't know. They seem to always get approved because they're like, here's what to make it habitable and, compliance and brand new washers and dryers and all the things. So I think probably there's always some sort of give there, but they'll put a plan in and they will say, and this is going to, fix property X. It's going to cost $1.2 million. And next thing the attorney general does goes to the Superior Court judge and says, order those guys, the owners who are not collecting rents anymore because the receiver's taking all the rents, to put in the delta between rents collected and how much capital is needed to fund the things, which let me tell you, 7 out of 10 times The owners don't have such deep pockets. Now, I've had
Yep.
a couple with deep pockets who decided they didn't want to comply anyway. I mean, they ended up in bankruptcy, but no one really is excited to cut the receiver like a, $700,000 check and let them pick their contractors and the order of operations and all that. But that's essentially what is supposed to happen. But yeah, so you get these where they're ordered to fund and they can't. So
Mhm.
again, they're still in control of the company. So instead of funding and being personally held liable or other court sanctions, contempt actions, they put the company in bankruptcy because there's an automatic stay there. Those are when I see them a lot of the times. Or if there's already been a contempt order, which I think we're going to get to kind of the biggest case I had on that in a bit. Sometimes they'll come in just to limit the effectiveness or to challenge whether or not what's being done is a police and regulatory exception or some other type of issue and how to maybe preserve the value. A lot of these properties, if they were fixed up, probably aren't underwater because
Yep.
a lot of them are either owned free and clear, they're legacy properties, but they're just in extreme disrepair.
Mhm. Well, so that kind of segues us into what you were just mentioning, which is this larger case that you've been talking about. Do you want to introduce that a little bit?
So this was a very large complex in Southeast DC. And if you're familiar with Southeast DC at all, it is the rougher part of the District of Columbia, but it was a 674 unit development over 5 buildings. It does a lot of low income housing, vouchers, Section 8, things like that, plus some private rent. It was bought by a conglomerate and owned by a doctor out of New York. And the allegations were from the district that over time, instead of putting the money back into the properties, because it was a functioning operating business when and managing itself, he took the money out and let the property go into disrepair. It was extensively litigated because he was one of the deep pockets. He did have money outside, and some of the other ownership had money outside. And he continued to refuse to fund. So over time, there was a remediation plan initially agreed to. It was not complied with in a timeline. I will say, I think sometimes the remediation plans in place by the court are a little fanciful because they say this property allegedly had mold in pretty much every unit, and they were going to remediate the mold, and the court ordered them to remediate the mold in 90 days. I'm pretty sure you could hire every mold remediation company in the District of Columbia to remediate the mold, and it would have taken more than 90 days. Ultimately, I think the mold remediation took 3 years.
Yeah.
And so
Gonna say I can't get a contractor out in 90 days for anything.
right, right. And I mean, when I say it took 3 years and somewhere over $3 or $4 million to do it. I
Mhm.
mean, just the mold remediation stuff. So it was, I'm not sure how you get compliance in 90 days. But that being said, they didn't comply, and there were a number of things they weren't compliant with. The district then went in on a motion for contempt because the order was a remediation. And the district judge, to his credit, he'd been dealing with this for like 3 years. And I think he was right. There was voluntary noncompliance. Like the owners clearly were not interested in funding some of these things because it was easier to take the money than not. And so he found them in contempt and he crafted what is a fairly unique order from what I've seen on this contempt, which is you're in contempt. Here are the 45 things you haven't done in the 2 years you've been given the opportunity to do so. If you haven't cured your contempt, and again, this is civil contempt, so you have to have a purge. If you haven't purged your contempt in 30 days, I'm ordering that you are only able at that point to collect 50% of the rent. So say the rent roll was 500 grand a month on 674 units, not a big number. And a lot of this was district controlled rents. So they're going to know if they have to
Mhm.
pay or not. He said if you haven't purged in 60 days, you can only collect 60% of the rent. And if you haven't purged in 90 days, you can't collect 75% of the rent. So it had an escalation clause for the longer they went. I might have the days wrong, something, but it was an escalation on this thing where they could collect less and less rent the longer and longer they went along. And the idea was that a lot of these voucher programs, the individuals still pay a piece of their rent. So if their
Mhm.
piece was 500, they would be compensated by only having to pay 250 or
Mhm.
100 or whatever. And That's what ultimately pushed them in because they got past the first purge time and realized they're not even close. And they filed in September of 2023, I think, either so 23 or 24. And the first motion was for me to declare that the contempt order and the escalations thereunder were unenforceable post petition. They wanted that as a first day motion. The district was not excited about that being a first day motion. They filed in September. We ended up having a 2.5 day evidentiary hearing in December. There was some stipulated consents along the way. There was a challenge to the existing receiver, whether they should collect rent. They stipulated to allowing the current amount to stand for a period of time. We had about 3 months where they were just collecting the 50% of the rent. But the question was whether there would be more in order to get to the evidentiary hearing. And
Mhm.
at the hearing, I got, I think, 7,000 pages. I got every one of the violations, which had photos, and we had testimony from the Department of Buildings. There was a committee of tenants represented. They had localized and had basically an ad hoc committee of tenants. So we had the president of the official tenants association. We had the representative of the tenants association. And I tried to express to everybody, I don't doubt that all of these conditions exist, but ultimately it comes down to a question of, is this contempt order enforceable as an exception to the automatic stay, which the district argued police and regulatory exception, or is it not? Is the debtor was arguing this is a violation of stay, we should be able to collect all our rents. And so we had a 2.5 day hearing, hear all this evidence, see all these witnesses. And I will tell you, I do hybrid hearings, so people come in person and they come by Zoom. I easily had 100 people watching most of these hearings. A lot of the tenants were very invested because this is their
Yeah.
house. This is whether or not it's going to be fixed up, what the timeline's going to be. In addition, legal aid had helped them all file claims because
Mhm.
now they're post petition and they're trying to
Yep.
sell the property and they're alleging six-figure, like hundreds of thousands of dollars of cure claims. Some had health issues.
Mhm.
They showed video. There was a video of during a rainstorm once, like all of the water came down into the parking garage and this fantastic, nothing. I didn't doubt that the conditions were that way, but it was really came down to a legal question of, was the purge, how did that work? How did this contempt purge? And so, I mean, I have an opinion out there. I wrote it on it. It came out and I ruled from the bench. I knew it was a really timely thing. So we took a weekend and I ruled from the bench on Monday morning. Took about 2 hours. I ended up writing it. So it's out there if anybody really wants to geek out on the police and regulatory exception. Let me tell you, it's thrilling. But what I held is that the contempt order itself and the finding of contempt and the order that the district obtained for the violations was clearly part of the police and regulatory exception. But what wasn't was the financial implications on the debtor's post-petition income, meaning they could continue to fine them and
Mhm.
accumulate a fine in the amount of the contempt amount, but they couldn't enforce the non-collection of the funds because the post-petition funds were property of the estate. So they had a receiver. A deal was cut to keep that receiver in place. There was some argument as to whether they should stay in place or not.
Mhm.
And ultimately, the property got sold. It took about 12 more months after that ruling for the property to finally sell because there were so many moving pieces. But it really made me dig into this idea of which of the actions which DC pursues in these buildings is truly a health and safety, police health and safety concern for the population. What ultimately becomes something that violates the automatic stay. And it was a really fine line, I
Mhm.
thought, to distinguish, but the case law is very clear that the police and regulatory is to enforce health, safety, community, all those things. It's not to collect money. And so
Yep.
we drew that line in the middle. Property's in new hands now. A case is still a little bit open. We have some remnants of insurance proceeds, which have nothing to do with what we're talking about
Yeah.
today. So I feel confident I can talk about this, but
Yeah.
it was quite an extensive case and really in this one, the receiver wasn't as involved, but they were saying, like, how do we do the rents? And they actually
Mhm.
worked very collaboratively with the debtor and at least administering the day to day, as opposed to this the question of who got what.
Yeah. So many questions to come out of this. I'll try to keep them simple and short and sweet. But we'll start with just what you just touched on, the receiver. So you kept the receiver in place. Let's start simple, right? Because there
Right.
are certain judges that say no, and there are certain judges that say yes.
I said you agreed. That sounds fine to me. It has been brought up in almost every one of these property cases that has this limited receiver. The debtor has moved to have the receiver removed, and ultimately it is settled. So I
Hmm.
actually haven't had to decide, other than I did have one very early on where it wasn't the debtor that was arguing, it was the U.S. trustee was saying, the code says you can't have a receiver. And I said, the code actually says I can't put a receiver in place post petition. It's silent on the question of whether that receiver can exist in some
Hmm.
sort of a, coexisting agreement with the property, the estate. I've never had to make that later half of that decision, which is how much can the receiver do post petition,
Hmm.
and how does their appointment order compare with what the police and regulatory exception might allow for, or 542 might allow for, or any of those things. Because all the credit to the District of Columbia's counsel and debtors counsel, they usually come up with an agreement, and it's not always the same. In some
Hmm.
cases, the debtor had the receiver doesn't want to do the day-to-day money coming in or not. So there's a wide range of where this ends up, but it's usually very fact specific. And so I've only ever made that first ruling. I haven't had to consider the last one, and it was very limited, which is the code says I can't put one in, and one cannot be appointed whilst in bankruptcy. However, it's silent as to what can exist, and I'm very thankful for all the excellent counsel involved who have made arrangements so that it has worked for each case to keep some involvement and to make them mostly successful.
Yeah. So shifting a little bit to another party in the case, the district. I won't ask you to tell us whether you feel they liked your ruling or not. Um, but has it convinced them to keep putting stuff in, or have they been changing up their method to their madness um,
I
after this decision?
I honestly I don't know because I don't see things until
Yeah.
management comes out. The one interesting piece is there is a notorious slumlord who has done some other things, and he ends up finding shills to file bankruptcies and then
Hmm.
trying to wash things through a false 363 sale. I made findings on the record that it was
Yeah.
completely fraudulent. I've had all that. The district actually, in a really unique and a first time thing in February of 2026, filed a RICO case against him and his brother,
Okay.
to try and he has a lot of properties that are in disrepair. It just lets them go, fines people to take ownership, and it appears misleads them. There's a lot of pieces, and the complaint is so. If I wanted, the only thing I can say getting creative is they've taken this guy on the
Hmm.
very first, from what we can tell, state DC Superior Court RICO case, which is very
Okay.
interesting.
Yeah.
Um, I think their enforcement arm within the scope of the various things still continues with these requests. I don't know if maybe they're changing their requests on contempt,
Hmm.
but certainly it's a limited situation that there's got to be something. You got to hit them where it hurts, right? So if that's where it hurts, then I
Yep.
don't know. But I haven't seen anything other than this very look. I watched the press release. It was fun to watch. I was like, oh hey, that's my lawyer, well, the one that comes
Yeah.
to court all the time, standing behind the attorney general as they announce this thing. So, um, yeah, that's the most interesting follow-up, and that really comes out more of a systematic alleged scheme to completely defraud,
Yeah.
renters.
So what do you think, knowing that our listeners are a lot of attorneys, a lot of receivers across the country, what are kind of some of those things that they might want to take away from what you learned as you walk through this case?
I mean, I think, and receivers will know this, that everything comes from the appointment order, and it comes from the scope of the power granted to them by the appointing court. I do think over time, having reviewed a lot of these appointment orders and reviewed a lot of these schemes of correction or abatement plans, they are getting more nuanced and more specifically set out with tighter timelines and with more detail because having, as you know, having a broad order can do a couple things. It leaves a lot of wiggle room and it doesn't create a lot of obligation and deadline. And so I'm not saying anything new to the receivers or attorneys on this case, but it begins and ends with that receivership order and whether or not you have what you need there, whether you have to come back for relief to get more of that, if you have to come and get an amendment. I mean, you never have the full picture, but one thing that's interesting about the limited receivers is there's usually been litigation for at least, 6 to 12 months in DC before they're involved. So they have more information than maybe your SEC receiverships who have just figured out there's a Ponzi scheme and there's enough to come in and set it up. So I would, get a great order, make sure it's very clear, Rooker-Feldman and all those other things that I can't change. We are in some ways bound by that as well, to the extent that it's not, there's not a conflict of law. There's a lot there that can be collateral estoppel or at least very persuasive in what authority the bankruptcy court may or may not have to change, modify, or allow relief. And so, yeah, I think, I don't think this is anything groundbreaking to the folks who do this on a day-to-day basis, but begins and ends with the appointment order. And really, the receivers themselves, if I always appreciate a practical approach. So if they come in and they're like, I'm doing this, but I'm happy to work with them or correspond with them, it's very helpful to at least keep the lines of communication open, especially once debtors has counsel. Giving them as much information I think as possible moves things forward because if the receiver has told the owner and their counsel has told the owner and it gets to me and I have to yell at the owner, I mean, they usually listen to me because I'm big and mean and have a black robe, but sometimes you just have to have that communication and we can read it between the lines. I get these pleadings like the owner is refusing to this motion to compel, and I was like, bring him in. I was like, come on now. Like, come on, son. Like, let's go. So, yeah, I mean, the receivership order and then maintaining and opening those lines of communication and really assisting debtors counsel because 99% of the time, debtors counsel had a guy walk in and go, the state's trying to steal my property. And, showing the background and explaining the history of the case. And this big one we were talking about, it took me like half a day or a day when it first filed just to get my hands around the 5 years of litigation. So remember, the person on the bench or debtors counsel is going to be the least educated person in this situation. And to the extent you can, yes, advocate for your position, but do it in a little, more informative, like here, it would help because it's all off the record and it certainly facilitates a quicker resolution.
Yeah, I work with a great attorney, and he always says the easiest explanation often wins, right? And that if I can easily explain it to you and their side is very complex, it's probably going to be easier for a judge who's got all these other cases going on all the time to say, like, all right, the easiest explanation is what I'm going to stick to.
I mean, and I don't want to sound like I do feel for like the people who live in these properties because a lot of times they can't afford to live elsewhere. They're on voucher programs. They're low income, very vulnerable, a lot of times not English speaking populations. And I try not to discount, I'm certainly trying not to discount that, but it doesn't help me to hear about all of that over and over and over again when that's not the legal question I'm being faced with. So when the attorneys try and come in and just spend some airtime to make people feel good about that I heard again that they don't have running water or that the management's not responding or that the door fell off again. If you have emotion on that, fine, let's deal with it. But I'm aware. I'm like an elephant. I almost never forget. And so just let's get down to brass tacks. And it's not a jury trial. You don't have to postulate. You don't have to put on a show. I'm aware. I get that this property's horrible and this guy's a slumlord and that's your opinion, but I have to make the legal decision on the legal issues. And so cool your jets, maybe might be the way to put it.
Yeah. Yeah, well, thank you so much. I really appreciate it. Cool your jets, I feel like is a really good way to end end the conversation. So I'm gonna cut us off a little bit there. I will throw out a little bit of plug for you. You also operate your own podcast, The Bad Boys of Bankruptcy. So where we talk a lot about cases that most of the world has never heard of in state court receiverships. You're talking about some of the biggest cases that we've all watched play out on TV and in newspapers and across the internet and on Twitter and wherever else. So if you're interested, please feel free to look up Judge Gunn's podcast. I know she has a number of episodes, and including you're going to be recording a live episode at our CRA conference this year. So we're really excited about that. We'll probably be teasing out what that episode will be about over the coming months. Thank you so much for joining us today, Judge Gunn. Is there anything you want to leave listeners with?
Thanks for having me, Eric. It's always nice. This is a fun group, and hopefully, even though a little different than your normal podcast, somebody got something out of this, and I look forward to seeing you again in person.
Thank you. Thank you for joining Navigating Receiverships, brought to you by the Commercial Receivers Association. Find more information at commercialreceiver.org and catch every Navigating Receiverships podcast by subscribing through your favorite platform today.